and welcome to Know Your Rights. This is the show where you hear directly from lawyers who break down the law and explain the rights of citizens on common legal issues that confront Belizeans on a regular basis. Tonight, we will be discussing your rights when engaging in pre- and post-medical intervention. It is essential for any individual receiving or registering to receive medical treatment to be aware of how they are protected, in addition to their own responsibilities. Joining us to give insight on this important topic is attorney at law, Sheena Pitts. Good evening and welcome, Sheena.
Good evening. Thank you.
Thank you for coming on the show and addressing a topic that is not normally very much addressed in the media. We don't hear about it a lot. Many times we go to the medical facilities or we need to see a doctor, and whatever the doctor says, we go with and we go and get medication for, and we trust that diagnosis. But this is a topic that actually introduces that you as the patient now have a responsibility on your side. So if you suspect that anything is wrong or something did not go quite right when you are dealing with a medical institution or a medical practitioner, are there laws that you can apply?
Well, first of all, to answer short, there is no specific law that says a medical facility must this or a medical practitioner must do that. However, we do have the civil area of law, not criminal.
Okay.
And in the civil area, we have the law of tort. And in enforcing your right or seeking justice for an injury or harm done to you or someone you know, you get to enforce that under the law of tort. Now,
Okay.
What is a tort?
Yeah.
It's very simple. It's a wrongful act or an infringement of your right, which leads to civil liability of the person who did that wrongful act or infringed your right.
Oh, okay.
And taking legal action or suing someone in the medical field now for that wrongful act is dealt with under the tort of medical negligence. When you hear negligence, you think, what is that? It's so common. It's that principle in law that says someone does something to you or fails to do something to you which they should have known or ought to have known would cause you injury or harm.
Okay.
And so then medical negligence with it is this higher standard that says you have a duty of care. And it means that a doctor owes you a reasonable duty of care.
Okay. Okay.
And skill to take care of you to the best of her ability. And she should prevent you from injury or harm.
Okay.
And that she should have or could have known that whatever she does could result in harm if she did not perform to the best of her ability or skill.
Okay.
Or make sure she followed proper or correct medical standards and procedures. So basically, that is it. That area, that civil area of law, under the law of tort, that deals with negligence, that says you ought to know that what you do could possibly cause me harm.
Okay.
And that in administering care to me, you must administer reasonable care. You must treat me with care and skill that you prevent me from harm.
Okay.
And if there is any harm, then someone should know, what can I do now?
Yeah.
So that is where we are. In understanding the duty of a medical practitioner to you, we go back to the core of what guides doctors, which is the Hippocratic Oath.
Okay.
And the Hippocratic Oath is as ancient as it can be. There's the classic version and the modern version. And let me go to the modern version. It basically is a statement by doctors when they become doctors.
Okay.
And I will read the ones that are pertinent for discussion tonight.
Okay.
I will apply for the benefit of the sick all measures which are required, avoiding those twin traps of overtreatment and therapeutic nihilism. I will not be ashamed to say, I know not, nor will I fail to call in my colleagues when the skills of another are needed for a patient's recovery. I will respect the privacy of my patients, for their problems are not disclosed to me that the world may know. Most especially must I tread with care in matters of life and death. If it is given me to save a life, all thanks, but it may also be within my power to take a life. This awesome responsibility must be faced with great humbleness and awareness of my own frailty. Above all, I must not play God. I will remember that I do not treat a fever chart or a cancerous growth, but a sick human being whose illness may affect the person's family and economic stability. My responsibility includes these related problems if I am to care adequately for the sick. So these are the guiding principles of doctors, right? And it is based on these principles that we can see where doctors are really obliged to do. Go ahead.
Yeah, no, I was going to just go in and say, anybody who's familiar with a bit of philosophy has been exposed to similar code of ethics, right?
Right.
And you touch on two very important areas, which I just wanted to talk about. First, you said a specific phrase, I know not.
Right.
Now, it's a tricky thing. And I remember we were talking just before we went on air, and you said it's not a clear-cut thing. It is really a case-by-case situation. And when you said, I know not, I think about one of my own family members, my aunt, who went through about 5 years of diagnosis, right? Literally 5 years of just trying this, trying that, just cannot figure out what. And it was found that the treatment that she was on did make the situation worse. But is it a mistake? Can the doctors be held liable? Can the facility be held liable in that case? Because harm didn't seem intentional.
Right, which is why we should not be quick to call medical negligence, or you want to sue a doctor, you want to take a doctor to court.
Yeah.
When a patient presents herself to a doctor, you must go through symptoms. Now, automatically a doctor listening to the symptoms will trigger in her that can be this disease or that disease. And as you go through the symptoms, the doctor is narrowing down for a diagnosis. So at the end of the day, if there is something you didn't think was necessary to tell the doctor, or something that just slipped from you telling the doctor, that may really be what causes you to get a misdiagnosis. And that is not a negligence. That is perhaps, to be fair and kind, a mistake. Is it negligence? No. You know why? You ask, what would another medical professional in that same position, given all those symptoms, would that other professional diagnose the same? Would it be the same result? So you can't always clear cut and say it is this or it is that. You have to go through it as a case-by-case basis, see what happened. And in terms of the harm, which I am going to jump a bit and get into how it is you resolve these issues. It is not all the time you need to go to court. Sometimes you could have a discussion with the doctor. I came here last year, you gave me this diagnosis. I wasn't necessarily satisfied. I went to another professional. This professional told me something very, very different. This professional explained to me that, well, my treatment has been prolonged because what you did before exacerbated my condition, made me a little bit worse. And so give yourself and the medical professional an opportunity to see how they can address it.
Okay.
Because we're human beings, all of us, all professionals are. And if it is you are faced with a patient telling you that what you did wasn't necessarily accurate,
Okay.
note I said accurate and not wrong, and therefore you would allow that professional to say, very well, let me see how I can assist. Let me see how I can turn you on to treatment, to some form of therapist. Let me make your financial burden a bit easier.
Okay, that power of open communication.
Right.
Yeah.
In law, we call it it's a form of mediation in that you try to see how you could settle disputes without first going to court. Because
Okay.
you present something like that to a doctor, and a doctor would, most definitely a reasonable person, say, man, let me see what I can do. And they
Okay.
would work with you. And if you have a situation like that, it's not as every medical incident occur. You say it's negligence and you go to court. Because sometimes going to court is costly.
Yeah.
And you would find yourself
Yes.
going to court only to find out that it's not negligence.
It's not negligence.
Right, and then you're left with a bill
Yeah.
from the doctor and your lawyer.
And your liar.
Right? So, like I said, each situation is case sensitive in that we have to know what's going on with your situation.
Okay.
So-
It's a very fine distinction between mistake and negligence, and we'll get much more into that when we come back. But right now we have to take a very short break. We'll be right back to continue the discussion on Know Your Rights when engaging in pre- and post-medical intervention. Welcome back to Know Your Rights. I am Khadija Usher, and our guest tonight is attorney at law Sheena Pitts, and we are discussing your rights when engaging in pre- and post-medical intervention. Sheena, I loved how you went through that Hippocratic Oath. It got out a lot of the main points that doctors and medical practitioners must live up to. One of the areas was privacy. Now, whenever you're seeing a doctor about a medical condition, this is something that you expect will be upheld. Tell us a bit about privacy and non-disclosure when it comes to your medical information.
Well, it is simply that. Whatever you tell your doctor is in strict confidence between you and that doctor.
Okay.
And it is understood and expected that he cannot and he should not disclose it to others. But let's get a bit realistic. If you're in a medical institution, if you're in a hospital, you know that the nurses who come to treat you and give you your medicine and those who may come in close contact with you may have some information as to the extent of your condition.
Okay.
So within that close network of people, medical professionals who dispense with care to you, they should hold your confidence. And where it is not, it's quite unfortunate because it breaks down that relationship between doctor and patient, the relationship between the institution and the patient, the institution and the society at large. People won't want to go to a doctor who they know will talk their business. People won't want to go to an institution where they know this person works there and that person works there and they will get access to your information and then they spread your business and that sort of thing. So in the interest of the integrity of the institution, the medical professional, and the relationship between the professional and the patient, yes, your information must be kept confident.
Would there be any situation where a doctor must reveal some of your medical data? For instance, if approached by the courts, if it is involved in a criminal investigation, if it's a part of a case?
The short answer is yes. If you receive an order by the court to provide medical records of an individual, it must be disclosed, but you have to, again, take it within the context of the circumstances. The court won't just order information on somebody willy-nilly or somebody not connected to something. So when your information is disclosed in court, it is in relation to a suit that you're litigating, and that is understood and is expected, because if you are alleging that someone was negligent to you, you have to set out, you have to prove what negligence. You have to say, well, I got diagnosed with this. The prescription for this diagnosis is this drug. I should get it at this time, every so much hours. Look at my drug chart. I didn't get it at that time. I didn't get it every 8 hours. As a result of not receiving it, so and so and so. A person with this diagnosis not getting their medication, this is what would happen. So there are circumstances where your medical records would be disclosed especially where you're at court and you're alleging negligence against a professional.
Would there be any situation where for some reason a patient is refusing care or refusing the treatment that is advised by the medical practitioner? Is that within their rights?
Of course. And it happens, you know. People refuse treatment for a myriad of reasons. One of the most common is religious. We're aware that in the Jehovah's Witness practice, they do not take blood.
Yeah.
And so if you are in the hospital and you need blood to help save your life, it is your right to say, no, I don't want it.
Okay.
Now, the other consideration then, when you die as a result of not receiving the blood, would you say the doctor was negligent?
Yeah.
If it is, not taking the blood is the direct correlation between your life and death.
Okay. In terms of refusal on care, and you touch on the religious issue, does it ever get into some shady ground in terms of refusing treatment may cause harm not to just yourself, but another person? For instance, when I was volunteering with the Red Cross, a classic case was mothers not necessarily wanting to know their HIV status or seek treatment if they do know that they are positive with it. In that case, another person or an unborn child might be at risk. Does it ever get shady for you in your experience?
Well, thankfully, mothers, when they're receiving care, when they're pregnant, prenatal care, they are screened, right?
Yeah.
And what I like about all our medical institutions, the different clinics, your HIV status is the first thing that is sought. Because if it is, you are HIV positive, that doesn't necessarily mean that your child has to also be HIV positive. There are things that can be done to enable you to deliver that child HIV free. Now, how far can the law trespass on someone's right, even though irrational, to refuse treatment in those circumstances?
Yeah.
Perhaps I'm disabused hereafter, but I am not too sure that we're at that place where that is happening.
Yeah.
You can go, a loved one can go to the courts for an order to try to compel you to do certain things. That is available, but in the final analysis, sometimes knowing your rights and exercising your rights could end up hurting you where it is you're being a bit irrational.
Yeah. So we'll get more into the making the decision and the responsibility of a patient, but we need to take one final commercial break. So coming up now is another episode in RFNG's educational series, Motor Act Insurance, after which we will take our final break. Welcome back to Know Your Rights. I am Khadija Usher, and our guest tonight is attorney at law Sheena Pitts, and we are discussing your rights when engaging in pre- and post-medical intervention. So, Sheena, we went through quite a bit of the responsibility on the side of the patient, as well as the perspective, the various perspectives you see from situation to situation on the side of the medical practitioners. Now, when you are going into a procedure such as surgery, you always hope for the best, right? But sometimes you do not get that outcome, and sometimes you believe that it is due to negligence. What recourse can you take, and what is the procedure?
Right. Well, first of all, know what your role is, what your responsibility is, because many times we go to the hospital and we take for granted that we can't ask questions, we can't try to understand exactly what's going on. And a part of knowing your rights is knowing that where you don't understand, you ask.
Okay.
And medical language is so technical, it goes above all of our heads.
Yeah.
Don't nod your head and say, yes, I understand, when you do not. You ask again. You ask so many times. Don't ever feel like you're asking too many questions or you're annoying anyone. It is your benefit to know. You see, when you ask questions, you know what is wrong. You know what needs to be done. You know what side effects. You know what could go right. You know what could go wrong. So when you ask questions, you put yourself in a better position to know what may or may not go wrong. So let's just say something goes wrong and you want to litigate, you want to go to court. My first word of advice: personal reflection, be patient. Do you have endurance? Do you have time? Do you have the money sometimes that it takes? And are you ready to take on a legal battle? And can you endure a lawsuit? A lawsuit for medical negligence can take years. And sometimes you might start off with that zeal to go through, and 2-3 years later, it's gone. So the first thing, know that the road ahead will be long.
Okay.
So you have to identify that something may have gone wrong, whether it is fatal or non-fatal. If it is non-fatal, you try to ascertain before going to litigation whether or not the healthcare institution or the medical practitioner can somewhat fix it or correct it. Give you some kind of mechanism that satisfies the inconvenience that you've gone through. No? If it is catastrophic or fatal, where you perhaps changed one medical practitioner, gone to another one, or you got a referral, so you know that something has gone wrong, and that it was directly connected to how the physician dispensed with care. And then you have to go through the challenges of proving that the doctor either did the best or did not do the best in the circumstances. Did she fail to exercise care and skill in the circumstances? Would another doctor do as she did? And so the biggest part of going to court on medical negligence is proof. A part of that is expert opinion. We need someone else to speak on what happened, another doctor to say, I wouldn't have done that like that. I wouldn't have given that medication. Or any other doctor in that position would not have done that. And where it is fatal, this is important, the post-mortem examination is so crucial. We overlook it because the post-mortem shows you what exactly happened that caused the death. And we have our pathologists in Belize, but knowing your rights, you need to know that you don't have to accept whatever pathologist is doing a postmortem on your loved one. You can decide that you want Dr. Sanchez to do it. And in doing so, you write to the commissioner and you ask for permission to use your specific pathologist. And so these are check marks that you have to go along. And then you ask, who is liable? Is it the doctor? Is it the hospital? Or is it both of them? Well, the long and short of it is, if it's a public institution, then it is the institution by virtue of the government. So when we go to Western Regional Hospital
Yeah.
or Matron Roberts and something goes wrong, when you sue, it's the government, because the government is responsible for the hospital.
Okay.
The government is responsible for the doctors there,
Yeah.
right? If it's private, you can choose to sue the institution as well as the doctor in their own name.
Okay. Okay.
Now, I think what we overlook sometimes, or what is lacking, is the insurance that doctors should be practicing with. Doctors don't really practice with insurance, so
Yeah.
there's liability mounting up against the government, and it really is unsavory, because we have some situations where one doctor or several doctors, when you hear questions of negligence, their name come up every time, every so often, and they're still working. Their liabilities, right? Recommendation to people who just cannot afford to pay their medical bill. I would say not having money does not mean that you cannot access medical care. It is a basic right. Some time ago, the Ministry of Health circulated a pamphlet informing people of their rights, that they have a right to receive medical treatment, and nobody can be refused from receiving medical treatment.
Basic medical treatment.
Right, your access to medical treatment cannot be refused.
Because I think that is still something very debatable.
Well,
the level of that access.
let me tell you, I did a short survey with public and private medical institutions, and all of them tell you the same thing, which is based on the Hippocratic Oath. They will not turn anyone away.
Okay.
What they would do is assess people on their case-by-case basis on what they can afford. Now, sometimes we have experiences where you're there sick, you can't really function, and someone is in your face telling you, well, how are you going to pay? What is your insurance? And that is rather unfortunate. But what we must always hold true to is that you cannot be denied medical care. However, there's an area where your religious denomination, your religious belief may prevent you from dispensing medical care to persons. I read recently where two women, married women with a 6-day-old child, they're complaining that their doctor refused to give their child medical care.
Okay.
And so when they're questioning this, they want to know, but why? How is that? What's going on with this? No, the elephant in the room is the discrimination.
Yeah.
On the other side of the coin, in a state, because this was in the United States, in Michigan, in a state where women can marry and that sort of thing, that was lawful, we have to balance it with religious beliefs. The doctor said that she had prayed, she had confided in the tenets of her religion, and at the end of the day, she felt constrained too. However, the important thing is, in so doing, she ensured that she referred those parents to another doctor.
She followed the proper protocol.
Right. So where we say you are not supposed to be refused medical care, that is true. However, there are situations where, especially in the face of human rights and constitutional rights and discrimination, someone can verily say that, well, my religious beliefs constrain me from doing this. Fine. Well, not fine, really. However, you still have a responsibility to ensure that that person receives medical care. So in that case, they referred them. There was no delay, there was no gap, there was no threat to health and well-being, which resolved the immediate problem. But the truth is, you still ended up refusing to see someone. Yeah. In our context, we have situations where gunshot victims end up in the hospital, and for some reason or the other, we don't know these people, they get tagged as ghetto, Southside, no life, doctor no one deal with them. Is that correct? No. Sometimes we have situations where the doctor is there trying to administer care, and family and friends there with the hostility to the doctor.
Panic.
Right. And
aggression.
when you're dealing with emergencies, when you're dealing with this, everyone needs to understand the role they play. We're all humans.
Yeah.
You cannot aggress the doctor. You cannot be hostile to the doctor,
Yeah.
although it's not right.
Yeah.
I mean, it is understandable that a doctor may decide, you don't know how to conduct yourself. Well, I know to deal with you or nobody for you.
Yeah.
It is not right. But the point is that everyone has a role to
Has their
play.
role and their
Knowing
responsibility.
knowing your rights is also knowing what your responsibility is. Be courteous, be calm, ask questions, know what's going on. You don't have money, it doesn't mean you can't get medical care. No, something goes wrong. Sit, think. Are you ready to go the 10 and 20 and 100 miles it takes
I like
to
how you
resolve?
distress it. I really like how you distress
Right,
it. And you
because-
definitely brought to us both sides of the coin, the responsibility from the side of the medical practitioners, the medical agencies, as well as the patients. But unfortunately, I know it's a heavy topic and you have a lot you wanted to cover. We have to come to the end of our show for tonight. Thank you, Sheena, for joining us and providing important information on tonight's topic. Tune in again next week as we will be joined by another guest attorney who will be breaking down your rights on another exciting topic. Tonight's episode of Know Your Rights repeats at 1 p.m. on Sunday on Channel 7, and it will also be available for your viewing on Facebook and YouTube. Thank you for watching and good night.